Hello, DAF families. We are now in the third video in our series about manifestation determination reviews. So let me tell you about the first two videos very briefly. In the first video, I introduced the concept that when considering disciplinary action for a child with a disability, there are certain protections in the law. As we discussed what those protections are, I introduced this concept of a change in placement. So our second video goes into a deeper dive about this concept of what exactly does that mean? What is a change in placement that would trigger the protections that we're talking about? And those protections, by the way, lead to this manifestation determination review, which is a meeting where folks gather together to say, is this child's behavior a result of their disability? So in this video, I want to talk about the team that should be making this decision. The team should have a representative from the school district, a parent, and relevant members of the IEP team. Parents often don't know this, but you can invite additional participants. The school can as well. So just ensure that if there is someone that you think is critical to being at the table when your child's behavior is being considered, invite them and let the school know that you'd like to invite them. I've mentioned in each of our videos so far, but I want to once again reiterate that an MDR should be done within 10 days of any decision to make a change in placement, unless we're dealing with one of the exceptions that I described to you in video 2. The team is required to review a lot of information before a placement determination can be made. This includes the IEP, the behavioral intervention plan if there's one, or other information such as teacher observations, attendance records, medical records, really anything that could be relevant. Parents are not expected to be medical experts unless, of course, you are a medical professional, but I would say that the DSM-5 might be useful in understanding the symptoms and manifestations of the disability as well. Kids may be seeing a therapist or have a physician that's working with them regarding these very same behaviors that are being manifested in the school environment. So those records might be critical to get a hold of. But as a parent, you know your child best. Any material that you think is actually relevant, bring it with you during the MDR. Here's a graphic to help you envision the work of the team. Was the conduct caused by or directly and substantially related to the disability? Or IEP team has failed to implement the IEP? Then the behavior is a manifestation. Removal cannot extend beyond 10 days. Change in services or placement can only occur if the IEP team determines that this is what the student needs. And the school must conduct a functional behavioral assessment, or an FBA, and either modify or establish a behavioral intervention plan. I mentioned this in more detail in another video, but let me throw this in here again. A dangerous exception does apply and allows the school to remove a child for 45 days for things such as possession of a weapon, drugs, or a serious bodily injury. AFBA, Functional Behavioral Assessment, identifies the cause of challenging behavior. It is not defined in IDEA. It may be defined in some state law, so certainly check within your state. What I can say is that an FBA should be conducted by a certified behavioral analyst, together with the teachers and the parents and other members of the team that understand and may be able to give some input as to what's going on with your child. If the child does not already have a behavioral intervention plan specifying actions to be taken to improve or replace challenging behaviors, it may be time to put one in place. Now let's talk about protections for students that might not have been found eligible for services under IDEA. If the school district is determined to have had knowledge that the student had a disability before the behavior occurred, your child may still be entitled to those protections. There are a number of ways the school may already have known. 1, parents could have expressed their concerns, hopefully in writing, to someone at the school or at the school district. Parents could have already requested an evaluation. Or Maybe even a teacher or some other person expressed a concern about a pattern of behavior to the department, special education director, or someone in authority, and yet nothing was done. Now, if the school is aware of the disability and the parents have refused any evaluation, or if the student has been evaluated and determined not eligible for protections on the IDEA, then now that's a different situation. The school will likely not be found responsible to have the manifestation determination review. I think this would be a good place to stop. Let's recap. This video focuses on who's on the MDR team, what the team needs to look at in terms of resources, and the decisions they need to make during the MDR meeting. We also discussed the situation where a child does not yet have an IEP, as well as how and under what circumstances we can impute knowledge to the school and still hold them responsible for the manifestation determination review. Reach out to the Central Cell or call your local installation legal office if you have questions, and we are happy to assist you. In the next video, we will take a quick look at some of the case examples involving manifestation determination reviews. I hope to see you there.